Thank you very much, President Denise, and it's my great pleasure on this very important day for you that I have the pleasure to introduce Cheryl Gwyn. I'm going to repeat the topic of her presentation because I'm not sure all of you will have seen it. What does the 15th March Christchurch mosque attack mean for the Inspector General of Intelligence and Security? And the thing is, what she's going to do today is to talk generally about that in order to describe for you what her actual services are. And my great friend Peter Cullen, of course, came up to me today and said that she was going to reveal my file. The reality is that she's really here to protect us. So that whatever there is in our files, if we needed some certainty that it was being fair and so on, she would look after us. So she was appointed as New Zealand's Inspector General of Intelligence and Security commencing on the 5th of May 2014, and it was a 3-year term at the time. And the incredible thing about it is at that stage you were expected to have been, basically had some previous experience in this, but her role was to come in fresh and with a kind of independence of thought. And so she did it so well for the first 3 years, they reappointed her for another 3 years. She's the first Inspector General then to be appointed under the amended legislation, which significantly expands the Inspector General's powers and resources, and it removes the requirement that the appointee be a retired judge. The Inspector General's role includes reviewing the legality and propriety of intelligence and security agency activities and investigating complaints relating to the agencies. The Inspector General has the power to initiate her own inquiries. I have the privilege of serving on her reference committee, and I'd just like to say that I think it would be really good in this modern age with Facebook and so on if we could think about even greater resources for the role that she plays. And I think you'll see this from the discussion today. She brings broad public law experience, having spent 10 years as a Deputy Solicitor General in the New Zealand Crown Law Office, where she provided legal advice and representation to ministers and departments, principally on constitutional matters, including Indigenous rights and human rights issues. She also provided advice to New Zealand's intelligence community, and she was Deputy Secretary for Justice. Prior to that, she worked for 2 major law firms. Cheryl, we're really looking forward to hearing from you.
Kia ora koutou, ko Cheryl Gwyn aho, kei Office of the Inspector General aho e mahi ana. Tēnā koutou katoa. Thank you, Suzanne, for your introduction, and thank you, all of you, for the opportunity to come and meet with you and talk to you this afternoon. As Suzanne said, I'm the Inspector General of Intelligence and Oversight. I'm an independent statutory appointee, and my team and I, and there are 9 of us in total, have oversight of New Zealand's 2 intelligence and security agencies, the New Zealand Security Intelligence Service and the Government Communications Security Bureau. And what I'd like to cover today, with time for questions and discussion at the end, are the following things. First, why is independent oversight of the intelligence agencies necessary? 2, what does oversight look like in practice? 3, what we don't do, and 4, what's ahead for us and for you post 15 March and the Royal Commission report when it comes out. So first, why is independent oversight of the spy agencies necessary? And there are 2 aspects to my answer to this question. First, the nature of the powers that the intelligence agencies can exercise, and secondly, the absence of other forms of oversight. So first, the powers, and I'm sure you know generally that intelligence and security agencies have pretty intrusive powers, but you may not know the detail of exactly what they can do. And in New Zealand, the agencies have lawful authority, if they get an intelligence warrant, to do a whole range of things which, if they were carried out by any other citizen, would constitute criminal offences. So, for example, they can get legal authority to covertly access computers, intercept phones and mail, break into people's homes to plant listening devices or cameras, put tracking devices on their cars, exchange highly personal or other information with both domestic agencies and foreign intelligence agencies and law enforcement agencies. And all of those powers play out in all sorts of detailed ways. And I think as a citizen, one would want some independent oversight of how those highly intrusive powers are exercised. The second reason why I think it's important that independent oversight exists is the absence of other oversight of those agencies. Both the NZSIS and the GCSB are now public service agencies. They're both listed in Schedule 1 of the State Sector Act. And under the new legislation that governs them, the State Services Commissioner appoints both Directors General. The standards of integrity and conduct that are applicable to other government agencies apply to the intelligence agencies too. So you might expect that it would be adequate for them to be subject to all of the usual regulatory mechanisms that apply to other public service departments. But there are some critical differences that distinguish the intelligence agencies. And mostly that's because of the highly secret nature of what they do. The very fact that they're doing these highly intrusive secret things means that they aren't, and it would be difficult for them to be, subject to the ordinary standards and mechanisms of accountability that apply to other government departments. So it's much more difficult for Parliament or for the news media and the public at large to hold them to account, as we can, at least nominally, with other public sector agencies. And I think the fact that we can't do that has the potential to significantly impact on the level of trust and understanding that the public has in the value, the role, and the effectiveness of the intelligence agencies. And and I'm sure for most of you it's a reminder of what are the other accountability mechanisms that apply to other agencies. Well, we have parliamentary accountability, accountability through the courts. We have various other forms of public oversight. Those mechanisms have a limited application to the SIS and the GCSB. So if you take parliamentary accountability, in this context it has two aspects. First, Parliament obviously sets the legislative framework within which the intelligence agencies operate, and we have the Intelligence and Security Act 2017, which is their governing legislation. Second, we have a committee of Parliament, it's a statutory committee called the Intelligence and Security Committee. And as I say, it's a statutory committee. It's not a committee of Parliament in the way that select committees are. So it doesn't have the power to undertake a detailed scrutiny of bills or conduct inquiries with the associated investigative powers that select committees have. What the ISC does is receive the annual reports from the intelligence agencies and does an annual review. But it doesn't have a right of access to classified material, which rules out its ability to look at virtually everything that the agencies do. And it can't inquire into anything that's operationally sensitive. So in effect, the statutory committee of Parliament has a very limited role in overseeing what the intelligence agencies do. Second aspect is accountability through the courts. And of course other public sector agencies are potentially subject to judicial review in the High Court, as well as being subject to the court's general jurisdiction and the specialist jurisdiction of the Employment Court. For all practical purposes, those judicial protections don't apply to New Zealand's intelligence agencies. In New Zealand, intelligence warrants, so to undertake the kind of intrusive and otherwise unlawful activity I mentioned, they have to have a warrant. Those are granted in New Zealand by the minister who is responsible for the agencies. And in some cases, the Commissioner of Intelligence Warrants, a retired judge, must also sign off the warrant. But they're not authorised by a court. So although, of course, the Minister and the Commissioner, I'm sure, scrutinise the applications very carefully, it's not the same as a judicial or court-like process. And you can contrast that with the process for the police, for example. When they want a warrant to exercise their powers under the Search and Surveillance Act, they have to apply to the court and answer the questions of the judge. And judicial review of the intelligence agencies virtually never happens. And the reason for that is a would-be plaintiff simply doesn't have enough information to bring a case. In fact, the only two cases of note in the recent past, the Chowdhury case in 1999 and the .com case in 2012, could only be brought because the agencies made mistakes which exposed exactly what they had been doing and brought that into public view. And then there are other forms of public oversight that apply to other government departments, so the Official Information Act, the Privacy Act, the Ombudsman Act, and they provide a significant degree of oversight and accountability for other government departments, but they're of much more limited application to the intelligence agencies, and I have to say, in practice, remain largely redundant, although in some respects the OIA and the Privacy Act do apply to the intelligence agencies. The Auditor General does have a role, but in a financial context, as you would expect. And the secrecy of the agency's operations mean that there's very little room for scrutiny by NGOs, journalists or academics, which in other contexts is an important part of public accountability. And the other aspect of oversight is the ability to complain, and that jurisdiction sits with my office. So in my submission to you as members of the public, all of those circumstances mean that external, independent and effective oversight is vital for our intelligence agencies. And the way our system is structured, effectively the Inspector General and her or his staff carry out that role, and we stand in your shoes as members of the public in our task of keeping the agencies accountable. So I'd just like to talk now briefly about what our oversight looks like in practice. And in order to be effective, oversight has to have some general characteristics. It needs to be independent from the agencies, independent from ministers. We need to have full and direct access to all of the records that the agencies hold. We need to be able to publish reports so we can say in public what we've found. And we need adequate resources and power to thoroughly investigate. And critically, we have an own motion inquiry power, which I think is vital. What we do in practice is we review all aspects of agency operational activity to assess their compliance systems. We investigate complaints, so any New Zealand person who thinks they have been or may have been adversely affected by something one of the agencies has done can complain to my office. We conduct inquiries, and these are on a much bigger scale than reviews, with an expectation of much greater public exposure of the results. And we have special powers, the same kind of powers as a Royal Commission, for example, to get at the facts and the truth when we're inquiring into something. And the first inquiry I have to say rather nervously did when just after I was appointed as Inspector General, was whether the NZSIS acted in a politically neutral manner in its approach to an OIA request which concerned Mr. Phil Goff, who was then the leader of the opposition. So this was 2 elections ago. Other examples of inquiries that we have on foot are into whether the 2 New Zealand intelligence agencies knew of or contributed to the CIA detention and torture program in 2001 and 2009, and we're currently inquiring into the agency's role, if any, in Afghanistan around the time of the Operation Burnham events. So our inquiry is running in parallel to the inquiry being chaired by Sir Terence Arnold. We also scrutinise all of the intelligence warrants that I mentioned before. So we look at them after they've been signed to see if they conform with the requirements of the legislation and whether what has been authorised is necessary and proportionate to the anticipated intelligence value to be gained under the warrant. We have to certify in our annual report whether the agency's compliance systems are sound. And finally, we are the appropriate authority for complaints from or about the intelligence agencies under the Protected Disclosures Act. One of the things that came into sharper focus after the Christchurch attacks is what Oversight does not currently do. And I've got a few things to say about that. First,